Start the call of the docket this morning. We're going to start with 2018 Baxter County criminal case 2018-512 State of Arkansas versus Michael Glavish. We also have a revocation case 2017-332.
Good morning, sir.
Good morning.
Your Honor, on all of Mr. Glavish's cases, what Mr. Etheridge and I have talked about pursuant to the request of Mr. Glavish is attempting to get him into John 3:16. And I don't think that the state has any objection to that. It's just a matter of getting the semantics worked out to get him to John 3:16.
You know, the state does not object to him doing that, as Mr. Cooper has said is correct. The concern for the state is getting him from here to John 3:16 and making sure that's the only place he goes. We've had some problems with Mr. Glavish in the past in his wanting to go back to the location he is not welcomed at, and that is a concern for the state, for the victims, and so we don't have a problem with him going there. We know we need some help, but that is our concern, is the semantics of getting him from point A to point B.
I have not been back to my house since y'all told me I wasn't allowed to go back to my house.
Michael, don't say anything more, okay?
Yes, sir.
Last Thursday, when he appeared before Judge Laser, was he arraigned on this charge?
No, sir.
I don't see an arraignment has ever been entered. The case has been on the docket for quite a while, but there have been no arraignment. The charges, so let's start there. The charges against him are that I have a breaking or entering a Class D felony and theft of property, a separate Class D felony. On those charges, how does he plead?
Not guilty, Your Honor.
We have notes about the discussion prior to this of John 3:16. Do we have an established drug problem involved, or is this?
I believe that there is an addiction situation here, Your Honor.
All right. Once again, I don't show on the petition to revoke there's ever been an arraignment on that either. Mr. Glavish, the court you're charged in a petition to revoke with the new charges against you. In addition, there's a battery charge from November of 2018, and that you failed to pay your supervision fees and had arrearages. All of those are the allegations contained in the petition to revoke. On those, how does the defendant now plead?
Your Honor, he pleads not true, and if he, Michael, he's pleading not true, and we waive the 60-day requirement.
Okay. Mr. Glavish, one of the reasons that people are appointed lawyers or have lawyers is for them to do the speaking for you. So I would advise you, as your attorney has tried to let Mr. Cooper handle things here in the courtroom, so that you don't make some kind of statement that can later be used against you in court. So at this point, we've got you arraigned now. What is the discussion about the John 3:16? What would he be? What would be the arrangement that's proposed here?
Your Honor, I believe I've spoken with his mother, and I believe that his mother would be the appropriate person. She's not a part of any of the alleged victims.
Excuse me, sir. Mr. Cooper, my mom's in California.
Okay.
She can't. She's in California. All I have is a friend that said that they take me. It's a friend of the family. is what we told you on the phone, sir.
Who would that be, Michael?
My friend Stephen Bailey.
Your Honor, as I was saying, I've spoken to his mother on the phone, and she has been a strong proponent of Mr. Glavish going to John 3:16.
Well, here's my concern. That's a long-term program.
Yes.
If you're going to enter John 3:16, there's going to have to be basically a complete waiver of not only the 60 days but of speedy trial. And we're going to have to set it off for a date substantially in the future. Unless we've got an agreement to plead him out, and that's the John 3:16 program is included in the disposition of his case.
You know, the state has made it very clear that regardless of what happens at John 3:16, the state plans to move forward to incarcerate Mr. Glavish because of the crimes he has committed.
We have Mr. Glavish then down on a scheduling order on the 2018-512 where he's set for trial the week of July 15th. He's also got a final hearing on April 18th. Those are dates on his schedule on that. I don't believe, and I would be setting on a revocation. I don't mind setting the revocation off to say the April 18th date. Revocation hearing off to the April 18th date. The court doesn't have a problem with that with the 60-day waiver. But these cases are on a scheduling order to be resolved in the time period that's well short of what John 3:16 timeframes are about. So I mean, I think John 3:16 is a good program, and it's one I'd like to see anybody who is addicted have an opportunity to go through if they're willing to be committed. It takes a great deal of commitment on their part. But the problem in this case is that we're looking at active cases on the docket, and we need we need to take that into account if he's we're just sending him over to a treatment program with the expectation he's going to come back and face criminal charges and perhaps, as Mr. Etheridge says, incarceration. Unless we're willing to, there's a complete waiver of speedy trial on the new charges and 60-day waive well out in the future, he's not going to be able to complete the John 3:16 program.
Your Honor, Mr. Glavish has told me he wants to go to John 3:16. As I said, I've been assured by family members that he wants to go to this program. I would like to at least give him that opportunity. I would, at this point, waive any speedy trial on his new charges. And I think he has 2 open files, and I would waive speedy trial in both. And I've already waived the 60-day in the revocation case. But I think the threshold question today is how we get him to John 3:16 from our jail, because I think that the only way we can do this is if somebody picks him up from our jail and takes him straight to John 3:16, they screen him, and it's on a Sunday that they do it. So we're going to have a structured sort of setting for jail notes so the jail will know what we've agreed upon.
Mr. Cooper, all I have is that one person that I can count on for a ride. Since I have a no contact order, I was see if I can get out on Saturday so I can go to my house and get clothes. I have to have an officer with me in order to get my belongings for the program and everything, and then go on Sunday morning like I'm supposed to. I'll be staying with my friend the whole time. I'm not gonna be going home without an officer present. I'm not trying to cause any more problems. I mean, I didn't do any of this stuff anyway. I mean, but it'll come out to light when it's supposed to.
Well, I will say again, the court would be glad to approve the program, but I don't feel that that's a, you know, I've released people before and had them not do what they're expected to do, and it's
I was
happened
planning on
multiple
going to
times.
this program
And,
before.
Mr. Glavish, let me speak for a minute. Let me tell you that I've been through this many times, and I've been embarrassed many times by the number of prisoners who have not gone. I've got them out of jail for a specific purpose, and they don't fulfill that purpose. So I'm going to have. I don't know you. I don't have any reason to think you would be lying. On the other hand, I don't have any reason to think you're telling the truth. So I'm completely ambivalent on that. I would want a secure arrangement, and what you've outlined does not sound like a secure arrangement to get you to John 3:16. Anyway, and as I've already indicated, the John 3:16 program, while I was a program I have great respect for, in the light of we're trying to handle this as a criminal case in the courtroom, and we have set time periods. We've got to deal with the case in a certain time frame, and at all times, we need to have you secured. So that is, we know where you are and have a reasonable belief that you will either get there or stay there. At this point, I'm not satisfied with the arrangement that's being proposed.
Your Honor, my proposal, and we're doing this in one other case, and I realize every case is different, would be that he be released at 6 a.m. on Sunday from our jail into the custody of this individual that he has told us, and that individual would take him to John 3:16, nowhere else, but straight to John 3:16. If he is accepted into the program, he stays. If he is not accepted into the program, that individual brings him back to the jail.
Do we know anything about this individual?
We do not, Your Honor, and that's one of the state's concerns.
I would have to get more information from Mr. Glavish on him, Judge.
He's a family man. He works at Ranger Boats. He's just offered to do this to me for me because he's a friend of my family and stuff.
Yeah.
He's the only thing I got, man.
You know, if we just had a phone number at the break for me to call this individual, then I could give the court some more information about him.
I would like before I'd even consider it, I'd like the individual to appear before me and be sworn in, and on the record agree to the things that we're talking about, so that he could be held responsible if he doesn't carry them out.
Your Honor, that is all that we would have right now in this matter, and I'm going to have Sheila go try to call this individual and see if he will come to court.
Okay. Based on what's been said here in court today, court is leaving the matter set for trial the week of July 15th in case 2018-512, and with a reappearance on April 18th based on in case 2017-332, based on the waiver of the 60-day requirement. The court is setting this matter down for hearing, revocation hearing on April 18th, and then I'm marking it to call later, and we'll see if we can establish what needs to be established to have Mr. Glavish released to go to John 3:16.
Mr. Glavish,
That's where it stands now.
the prosecutor has inquired How old is Mr. Bailey?
He's older than I am. He's about in his 40s,
Okay, all right,
50s, maybe.
All right.
thank you.
You may be excused, sir. Two 2018-385, State of Arkansas versus Derek Quarles. Mr. Quarles in this case is appearing for arraignment. Has he applied to the Public Defender's Office as Judge Laser directed?
This time we did not have an application on Mr. Quarles.
Mr. Quarles, did you turn in an application for the Public Defender's Office, sir?
I filled one out, and I went to go turn it in here at the jail. And they said that a public defender would be up here to take the application from me, and public defender
so
never come up.
No.
I mean, I have the application in my hand right here. It's filled
All right.
out. But I mean, they said someone's supposed to come up and get it from me and talk to me.
That case is assigned to the Division III docket of Judge Putman. And we're going to do the arraignment on that. We also have a revocation case. Let's see where that stands. 2018-194. Apparently he appeared before Judge Laser a week ago and was set down for a revocation hearing today. I don't see any note in the docket that he was arraigned at that time. On case 2018-94, Mr. Quarles, you're charged by a petition to revoke with that in September 6th, it would have been less than a week after you entered your plea and were placed on probation, you were found to be in possession of drug paraphernalia and possession of controlled substances. It's a violation of two different terms of your terms and conditions of probation. On those charges, how do you now plead?
Not guilty.
I'm noting a plea of not true on that case. Have you made application to the Public Defender's Office on the revocation case?
Yes, Your Honor.
And had somebody been appointed? You all don't have an appointment on that either?
I guess not.
This one is definitely on my docket. I don't see it's been transferred. So,
I come in court last week, and they said that something to do with they scheduled it for today.
right, I see that.
I don't know why. I mean,
But,
they said,
well, that's because the judge was substituting for this court last week, and so he set it down for hearing today. But I don't see anywhere on there that the public defender was representing you or anything, so it does appear there was a bond set on it.
yeah, he
So-
gave me a $5,000 cash bond.
All right, here's I'm going to direct that you fill out an application to the Public Defender's Office, a second application. This is on case 2018-194, and you turn them in, and those are both going to have to get to the Public Defender's Office, by whatever means. The court is what the court's going to do is set this down for reappearance on February 7th when I'm next. That's the next time I'm here, and if we can. I may be over here next week for jury trials. I don't know what that schedule's going to work out to involve, but I'm next here for court on Friday the 7th of February. At that time, I want Mr. Quarles, I want you to have attorney appointed. I'm noting a plea of not true on the one case. I'm entering a plea of not guilty on the 2018 385. I want you to have talked to an attorney by the time I come here on February 7th. If for some reason, I don't know what the bond was on 2018 385, but you got a bond set of $5,000 on 2018 194, and it's set down right now for revocation hearing on that February 7th day. But you've got to get an attorney in place before we're going to proceed. So,
You think I could have a bond reduction?
You know, that was addressed last week by Judge Laser. Judge Laser set the same bond in both cases, Your Honor.
so the $5,000 is to cover both?
Yes, sir.
Okay. Your bond is $5,000 to cover both. Court's going to leave the bond where it is. Judge Laser is an experienced judge, and I trust his judgment on the appropriate bond on this. And so your bond is $5,000 cash or professional. If you make that bond, you need to understand you have to be in court in front of me at 9 o'clock on February 7th. And it's your obligation to get here. In the meantime, you need to turn those applications in to the jailer. They have a place to put them over there, don't they, Mr. Cooper? Mr. Cooper, at the jail, don't they have a place to put them?
They do, Your Honor, and, but if he will fill it out and give it to the jailer, we're gonna go over there at lunch.
Okay.
I have it
We'll
right here
pick-
in my hand,
Well,
filled out already.
Give it to the jailer, please, and fill out one for this case and for the Revo both. And give it to the jailer and we'll pick it up at lunch.
All right. Let's see if we can't get that done.
Yes.
So that on February 7th, he appears on both cases in front of me. Judge Putman's not going to be here until February 14th, so I don't want to put this off any longer than we have to. I'll do his appearance before me on case 385, 18385, and depending on circumstances, we may transfer them, but so that they're both on the same docket, particularly if there's any chance they can be resolved together. That'll be the order of the court. You may be excused at this time. (2018-19-34) State of Arkansas versus Robert Anderson. Mr. Anderson is before the court today for arraignment. Has he made application to the Public Defender's Office, Mr. Cooper?
He has, Your Honor.
All right. I'm reflecting the Public Defender's Office. And you've already been appointed. Is that correct?
Mark, he's going south.
Yes, Judge, we have.
Good. All right.
He's going south.
The court is charging, the court is arraigning Mr. Anderson on charges of possession of methamphetamine with purpose to deliver a Class A felony, possession of marijuana with the purpose to deliver a Class D felony, possession of drug paraphernalia, methamphetamine, a Class D felony, charged as an habitual offender, one enhancement provision, and also the felony drug offenses are alleged to have occurred in the proximity of certain facilities, adding an additional enhancement provision. On those charges, how does the defendant now plead?
Not guilty.
Court is noting his plea of not guilty on the record. Court will set the matter. Court is setting the matter on a trial schedule with trial set during the week of July 15th, a reappearance on April 18th. Any other matters to come before the court?
Your Honor, I've been informed by the state that Mr. Anderson has waived parole, and that I believe that he will be going to the penitentiary, so bond is not an issue on the parole situation.
All right, we'll move forward then. You may be excused, sir.
Yes, sir. Can I say something, Your Honor?
Yes?
I signed up for the Care Center Minister Program, and I had an interview Friday, and my public defender said yesterday that he was going to
running across to you today. He said it was left up to the prosecutor and the judge. And he said if you approve it, that I can go today to the paramedics program for a year.
Your Honor, I have mentioned that to Mr. Etheridge, and the response from the state, well, I'll just let Mr. Etheridge, I'm not going to speak for him.
Was no, Your Honor.
All right. Apparently, you do not have an agreement on that, that Mr. Cooper has followed up and made that proposal to the prosecutor, and the prosecutor has declined that as a possible disposition of your case.
It's what now? I don't understand.
Sir, that would only have worked out if there had been an agreement reached to do
Oh, yes,
that
sir.
between the prosecutor and your attorney. There's no agreement. Therefore, Mr. Cooper has followed up on that, and the prosecutor has turned down that arrangement. So that's not happening.
Yes, sir. I appreciate it, sir.
You may be excused.